Good day. It's my pleasure to bring this series on corruption and economic crimes. My name is Hakeem Olajide Bello. I'm of the Department of Public Law, Faculty of Law, University of Lagos. So in this series, we'll be looking at corruption and economic crimes. The objective of this presentation is to enable students to have an understanding of the meaning of corruption and economic crimes, and also to have an understanding of the ingredients of the offense of bribery and related offenses such as extortion, unlawful enrichment, and money laundering. At the end of the presentations, we expect that students should be able to explain the meaning of corruption and economic crimes and the ingredients of the offense of bribery and related offenses such as extortion, unlawful enrichment, and money laundering. We're going to start with what is corruption. The World Bank defines corruption as the abuse of public office for private gain. We can see easily from here that the focus of World Bank's definition is on public office or what public officers do in public office. So when a public officer abuses his office for private gain here has to do with purposes not connected with the public office. Where a public officer abused his office to earn private gain or private reward or private benefit, that is an act of corruption. But the problem with this corruption is that it focuses only on abuse of public office for private gain. And we know that corruption is, expands beyond public office. There are also corrupt practices by private sector officers in the private sector. And corruption should be broad enough, the definition of corruption should be broad enough to cover the activities of both public office participants and public sector participants. Transparency International has defined corruption as the abuse of entrusted power for private gain. Here, the focus is not only on public sector participants. The focus is on abuse of entrusted power. And this could either be in public office or in private sector. When entrusted power is abused for the purpose of private gain, so this constitutes corruption according to Transparency International's definition. Corruption has attracted global attention with the adoption of the African Union Convention on Preventing and Combating Corruption and the United Nations Convention Against Corruption. These are only examples of conventions on corruption that relates to Africa. There are other international conventions on corruption for other regions of the world. The Nigerian government has signed and ratified these conventions, which means that Nigeria is now obliged to enact domestic legislations to implement the provisions of this corruption. And in the course of these lectures, we will see the provisions of some of the legislations which Nigeria has enacted to implement the provision of this convention, or which can be taken to be an implementation of the provisions of these conventions. The conventions that I highlighted, the African Union Convention and the UN Convention, do not provide a definition of corruption. What they have done is to list various acts and practices that constitute corruption, such as bribery of national public officials, bribery of foreign public officials, embezzlement by public officials, embezzlement of property in the private sector, trading in influence, abuse of function, illicit enrichment, bribery in the private sector, laundering of proceeds of crime, and concealment. The Corrupt Practices and Other Related Offences Act 2000 defines corruption to include bribery, fraud, and other related offenses, Section 2. We can also see here that the approach adopted in the Corrupt Practices and Other Related Offences Act is to define corruption by listing various acts and practices that constitute corrupt practices. A similar approach is also adopted in Chapter 12 of the Criminal Code, criminalizing manifestations of corruption such as bribery, embezzlement, fraud, abuse of powers, and related offenses. What are economic crimes? Corruption is often described as or associated with economic crimes. Economic crimes have been described as illegal acts committed within business to gain economic advantage. So economic crimes are acts that are illegal by the provisions of the law, acts that have been criminalized by the provisions of the law, when those acts are committed during business transactions for the purpose of gaining economic or financial advantage. Those are economic crimes. Section 46 of the Economic and Financial Crimes Commission Establishment Act 2004 define economic and financial crimes as the non-violent criminal and illicit activity committed with the objectives of earning wealth illegally, either individually or in a group organized manner, thereby violating existing legislation governing the activities of government and its administration. So the focus of the definition is on illegal activity committed with the objectives of earning wealth illegally. So any activity that is illegal, that is declared to be a crime, and is targeted at the objective of obtaining or earning wealth illegally constitutes economic and financial crimes. And then the provision then went on to list various activities that constitute economic crimes by providing that it includes any form of fraud, narcotic drug, trafficking, money laundering, embezzlement, bribery, looting, and any form of corrupt malpractices, illegal arms deal, smuggling, human trafficking, child labor, illegal oil bunkering, illegal mining, tax evasion, foreign exchange malpractices, including counterfeiting of currency, theft of intellectual property, and piracy, open market abuse, dumping of toxic waste, and prohibited goods. We can see that these are all illegal activities which have been declared as crimes under various legislations, and they are targeted at criminals whose objective is to earn wealth illegally. The term economic crimes is associated or sometimes used interchangeably with white-collar crimes, business crimes, or financial crime. The above definition also covers all the corrupt practices earlier mentioned under the definition of corruption. Now we want to move on to the offense of bribery under Section 98 of the Criminal Code. The title of Section 98 of the Criminal Code describes the offense as official corruption, although the word bribes is also used in the title. Section 98 covers the demand side of bribery, where a public official invites bribe on account of official function. The actual use of the demand side of bribery is when a public officer asks for, receives, or obtains any property or benefit of any kind for himself or any other person, or agrees or attempts to receive or obtain any property or benefit of any kind for himself or any other person. Now, the actual use can be divided into two, where the public officer asks for, receives, or obtains any property or benefit of any kind. Or alternatively, where he agrees to receive or obtain property, or where he attempts to receive or obtain property. Now, in the second scenario, once there is an agreement to receive property on account of official function, the offense is constituted. Or once there is an attempt to receive, he is attempting to receive property or benefit of any kind in the course of official transaction, that will also constitute the offense, even though he is only attempting, he has not successfully obtained or received the property. So we need to note that. Now, the subject matter of the offense is property or benefit of any kind. Property is straightforward. That could be real property, could be property such as land, money, or any other kinds of property. Then the second half deals with benefit of any kind. Now, so that shows that it need not be property. It could be a benefit. It could be an advantage that has been conferred on the public officer. Maybe he received an advantage in terms of being given a benefit, maybe on account of his official function, somebody promised to offer him a job, or somebody offered to give him an assistance, to secure a contract or any other benefit, provided that the receipt of the benefit is connected with official transaction. The subject matter of the offense of bribery under section 201B subsection 1 of 18 U.S.C. of the U.S. is a thing of value. 18 U.S.C. United States Code, that is a legislation that deals with federal bribery under federal legislation in the U.S. And the subject matter of the offense under that legislation is a thing of value. And this thing of value has been interpreted in the case of United States versus Williams to include anything that has subjective value to the recipient. So once the thing has subjective value to the recipient, once it is something that he values, however subjective that value may be, that is sufficient to constitute the subject matter of the offense of bribery. And it is my belief that benefit of any kind will also cover what constitutes a thing of value under the provisions of the U.S. legislation. Now, in United States versus Girard, the court held that information constitutes a thing of value. So if somebody gives me a very critical information that gave me an advantage in a transaction or in a business or in an endeavor, and that information is given to me as a public officer, I asked for or demanded that information corruptly in the course of rendering a public service. So that information that is given to me is a thing of value because it is something that is of subjective value to me. So information has been held to constitute a thing of value. Now, in the case of United States versus Girard, the court reviewed prior cases under various statutes holding things of value could encompass sexual intercourse. So if I ask for sexual favor in order to render my duty as a public service, that is a benefit of any kind. So that sexual favor constitutes the property or benefit of any kind for the offense of bribery. And the court has also held that the promise to reinstate an employee is a thing of value, and an agreement not to run in an election. If I ask you not to run in an election as a benefit for which I rendered a public service, that can also constitute a thing of value, and I believe that should also constitute benefit of any kind for the purpose of the offense of bribery. So different things can constitute either a property or benefit of any kind. The mental element of the offense of bribery. The mental element of the offense of the demand side of bribery is corruptly asking for or receiving any property or benefit of any kind on account of anything already done or omitted, or favor or disfavor already shown on account of official functions. A critical component of the mental element of bribery is corruptly asking for or receiving any property or benefit of any kind. Now, the criminal code does not provide any definition for the word corruptly, and it has been left for the courts to reason out what constitutes corruptly. In other words, it is not enough to prove that a public officer asks for, demand, or obtain, or attempts to obtain property or benefit of any kind on account of official functions. It's not enough. That demand, that asking, that obtaining, that receiving must have been done corruptly. So what constitutes corruptly in this instance? In the case of Biobaku and the police, by Ramian J. explained the meaning of corruptly as follows. The notion behind Section 98 is this, in my view. An officer in the public service is expected to carry out his duty honestly and impartially, and this he cannot do if he is affected by considerations of benefit for himself or another person. And the mischief aimed at in Section 98 is the receiving or the offering of some benefit as a reward or inducement to sway or deflect the officer from the honest and impartial discharge of his duty. In other words, as a bribe for corruption or its price. Now, what the court is saying is that the notion of corruptly, explains the fact that when a public officer is rendering public service, he is expected to carry out his duties honestly and impartially. A public officer is expected to carry out his duties honestly and impartially, and is not to carry out his duties affected by any consideration for himself or another person. He's not supposed to carry out his duty in consideration of any benefit for himself or any other person. He's supposed to carry out his duties honestly and impartially. So what Section 98, the mischief Section 98 aimed to address, is where a public officer receives a benefit as a reward or as an inducement to sway him or deflect the officer from the honest and impartial discharge of his duties. So, when a public officer asks for, demands, obtains, or attempts to receive a property or benefit of any kind, is he attempting, asking, or obtaining to receive that property as a reward or inducement to affect him in his honest and impartial discharge of his duty? If that is the purpose for which he is accepting, asking, demanding, or receiving that property or benefit of any kind, then he has committed an offense under Section 98. So the idea is this. Okay, let me give an example of myself as a law teacher. One of my responsibilities as a law teacher is to grade student scripts. Now, how will you feel if you were to hear that a criminal law student approached me a day before, some days before criminal law exam, and said, "Sir, I've been wanting to appreciate you for quite a while," and he brings a Rolex wristwatch. I mean, a Rolex wristwatch now will probably cannot cost less than 500,000 naira. And he brings a Rolex wristwatch and says, "Sir, I just want to use this to appreciate you. Okay? I just want to use this to appreciate you." And I receive it and say, "Oh, thank you very much." And then subsequently, you guys heard that that student had an A in criminal law. And incidentally, that student also failed all other courses. It's only in criminal law that the student had an A. So what will you likely think? You will likely go away with the impression that, okay, he failed other courses. Okay, he must have bribed Professor Bello with that golden Rolex wristwatch. No wonder, there was no way he could have passed the criminal law otherwise than he gave that that Rolex wristwatch as a bribe. So now, the way the law will construe that is that, number one, I am a public officer. I'm supposed to discharge my duty of grading criminal law scripts honestly and impartially, without consideration for any benefit. Without consideration for any benefit. Okay? But by receiving that wristwatch from that student, an average onlooker, who is aware of what has transpired, will probably have an impression that that wristwatch was a bribe intended to sway me or deflect me from the honest and impartial discharge of my duties as a law teacher. And again, you will see as we go on that there is a presumption of corrupt receipt where a public officer receives a property or benefit of any kind in the course of his official transaction. The law presumes that he received them corruptly. So there is a presumption of corrupt receipt. So in this instance, if I'm charged under Section 98 or Section 98A for receiving bribe, I will have a duty of proving that that receipt was not with a corrupt intention. The law presumes that as a public officer, whenever I receive a property or benefit of any kind in the course of my official transaction, that is received or demanded corruptly. Okay? Now, in Ojo and Another versus Federal Republic of Nigeria, 2008, Law Pavilion Electronic Law Report, the Court of Appeal held that the word corrupt in Section 9(1) of the ICPC Act. ICPC Act is the Corrupt Practices and Other Related Offences Act. Similar to Section 98A of the Criminal Code, simply connotes the impairment of a public officer's duty by bribery. Impairment. So the asking or receiving of the property or benefit of any kind must have been done to impair the public officer's duty, to impair the performance of the public officer's duty, to act honestly and impartially. And that is the intent behind, that is what makes the asking, the giving, the obtaining, or the attempting to obtain a property or benefit of any kind corruptly for the purpose of that provision. Like I said earlier, note the presumption of receiving property corruptly in Section 98(2). Section 98 subsection 2 creates a presumption of corrupt receipt where a public officer demands, asks, or receives any property or benefit of any kind. The law presumes that there is corrupt receipt, meaning that the public officer now has the burden of proving that the property was not corruptly received. So all the prosecution needs to prove is, number one, that the defendant is a public officer. Two, in the course of his official duty, he asks, demands, obtains, or attempts to obtain a property or benefit of any kind. And the mere receipt raises the presumption that the receipt was corrupt. See generally the case of Muhyiddin against the state, 2019 Legal Law Pavilion Electronic Law Report, where the Court of Appeal outlined the ingredients of the offense of official corruption, bribery, under Section 98 of the Criminal Code Law of Ogun State, similar to Section 98 of the Criminal Code, as follows: that the appellant was employed in the public service, that he was charged with the performance of a duty by virtue of such employment. The duty to be performed should not touch on the administration of justice, that he corruptly asked and received property or benefit of any kind for himself or any other person, that he received the property or benefit on account of anything already done or omitted to be done, or afterwards done or omitted to be done by him in the discharge of his the duties of his office. So these are the elements that must be proven to sustain a charge under Section 98. Now, we should note the criticism of the mental element of bribery under the Criminal Code. Now, the Criminal Code merely uses the word corruptly without explaining the meaning of that word. Okay? And that in itself is not adequate, because the reason is that the criminal law is supposed to regulate conduct. And if the criminal law is supposed to regulate conduct, then the criminal law should be specific and clear as to the nature of the conduct that it is regulating. So it took Byrenian J in Biobako and the police to expand on the mischief behind the provision. But it would have been better if the law clearly delineates what is meant by the word corruptly. Now, it's important for us to note that the requirement of corruptly has been removed from the provision of sections 63 and 64 of the Criminal Law of Lagos, 2011. See also section 71 and 72 of the Criminal Law of Edo State, 2022. Now, what the implication of the wording of the provision may signal the intention to make the offense of bribery one of strict liability. Once the act of demanding or receiving bribe is proved, liability will attach without the requirement of proving any mental element. Now, the effect of the new provision under section 63 and 64 of the Criminal Law of Lagos and section 71 and 72 of the Criminal Law of Edo State, removing the word corruptly, is that once it is shown that the public officer demanded, asked, obtains, receives, or attempt to obtain or receive property or benefit of any kind in the course of official transaction, then the offense is complete. In other words, the prosecution does not even have to prove the corrupt intent. So, the rule then appears to be that for public officers, once you ask for, obtain, demand, or receive any property or benefit of any kind in the course of official transaction, that constitutes the offense of bribery. That would take away, the difficulty or the challenge on the part of the prosecution of having to prove corrupt intent. So once it can be shown that the public officer has asked for, demand, receives, obtains, or attempt to obtain any property or benefit of any kind, then the offense is complete. This will make the task of the prosecution in establishing the offense relatively easier. Okay? Note that under the criminal code, a public officer proven to have accepted to have received a bribe with the requisite mental element is not allowed to raise the following as a defense. So a public officer who is shown to have received a bribe with the following mental element of corruptly under the criminal code is not allowed to raise the following as a defense. One, that he did not subsequently do, make, or show the act, omission, favor, or disfavor in question. In the example that I gave of a student giving me a Rolex wristwatch, I will not be allowed to prove that, look, the student got, the A he got was deserved. I didn't show him any favor. I didn't do anything impartial in his favor. I will not be allowed to prove that. Because once he has given, I have received from him, I've demanded or received from him a property or benefit of any kind, that is prima facie evidence of corrupt intention. So I will not be allowed to show that I did not do him any favor, or I did not do what he wanted me to do. Even, let's even assume that the student expressly said that, sir, please, I know I did not do very well in the criminal law, but I would like to make an A. So, sir, whatever you can do for me, I would appreciate. And then he gives me the golden Rolex wristwatch. This one is even different from the first scenario I gave. In this second scenario, we were actually expressly trading, I was actually trading my office. Because the student expressly informed me that he didn't do well and he would like to receive an A. And then he gave me the golden Rolex wristwatch so as to corruptly induce me to favor him. So even in that kind of a scenario, where it was based on an express request for favor, I will not be allowed to show that the student actually deserved the A that is scored in the exam. I won't be allowed to show that, because the law has already presumed that by merely receiving it from me, I have had the corrupt intention. Then two, The defendant will also not be allowed to raise that he never intended to do, make, or show it. For example, maybe I knew that I was not going to participate in the grading of the criminal law scripts. I knew that I was not going to grade the criminal law scripts. So there was no way I was going to mark the script and give him an A, because shortly before the exam, I had commenced my sabbatical leave, and I was out of Nigeria. I traveled out of Nigeria to do my sabbatical leave in a UK university. But I collected the Rolex wristwatch before I traveled. I will not be allowed to prove that I never intended to do what the student asked me to do. I will still be liable for the offense of bribery under Section 98. Okay? Now, so we're going to look at the offense of bribery under Section 98A. We have been looking at bribery under Section 98, which covers the demand side. The demand side is when the public officer asks for the bribe, demands for the bribe, obtains the bribe. Now, Section 98A covers the supply side, where any person offers a bribe to a public officer. Now, the public officer is not demanding or asking for the bribe. The initiative for the bribe did not come from the public officer. The initiative came from any person. Okay? The actus reus of the supply side of bribery is when any person gives, confers, or procures any property or benefit of any kind to, on, or for a public official, or promises or offers to give or confer or to procure or attempt to procure any property or benefit of any kind to, on, or for a public official. Excuse me. So this provision covers a situation where somebody who is not a public official or any person offers a bribe to a public official. Maybe you go to a ministry of works, you bidded for a contract, and you approach the commissioner for works and says, Oga, I've bidded for this contract. The contract sum is 5 million naira. If you give me the contract, I will give you 1 million. Okay, so that is a person offering a bribe to a public officer. The actus reus of the offense, again, must have been done corruptly on account of official function. And the same meaning of corruptly given in Biobaku and the police applies. In the example of the person who has approached the commissioner for works, the commissioner for works is supposed to assess the bid by all contractors fairly, impartially, and honestly, and award the contract to the most qualified contractor. But in this instance, somebody has offered to give him 1 million. So his duty to act honestly and impartially has been compromised. Okay? So the same meaning of corruptly as given in Biobaku and the police applies. There is also bribery under Section 98B of the Criminal Code. Section 98B of the Criminal Code criminalizes the conduct of any person who invite bribes on account of actions of public official. You know, this will cover a situation in which somebody is an intermediary and he says, oh, don't worry, I know you have applied for a contract at the Ministry of Works. If you give me 500,000 naira, I will make sure that I reach the people in the ministry and you will get the job. Okay? And he collects the 500,000 naira from you. So he's inviting bribe on account of actions of a public official. He need not give any money to the Commissioner of Works. What the provision is criminalizing is a person inviting bribe on account of actions of a public official. Now, we need to say a word or two about the scope of bribery under sections 98, 98A, and 98B. Under sections 98, 98A, and 98B, particularly sections 98 and 98A, bribery in those provisions, in fact, in relation to 98A, and 98B, relates to actions of a public official, either as a public officer himself demanding for the bribe under section 98, or under section 98A, the public officer is the one offered a bribe by another person, or under section 98B, on account of the duties of a public officer, another person is asking for a bribe from another person. So all the three scenarios in 98, 98A, and 98B all relates to official actions involving a public official. Now the question is, you will remember at the beginning when we were looking at the definition of corruption, we criticized the definition of corruption by the World Bank, which defines corruption as the abuse of public office for private gains, by saying that the focus is only on the public sector. That criticism is also available against sections 98, 98A, and 98B. Bribery is not only confined to transactions involving public office. Bribery also occurs in transactions involving only private officials. The manager of company A may bid for a contract in company B and bribe the procurement officer in company B to award the contract to company A. That is bribery, because the procurement officer in company B is employed to exercise his function honestly and impartially, without regard to any consideration personal to himself. But by receiving bribe from company A and awarding the contract to company A, that is bribery. And it is the same thing that is wrong with bribery involving public officials that is also applicable in bribery involving non-public officials. And that is why the provisions of the code has been criticized for only narrowing bribery only to public officers. Now, we will look at the provisions under the ICPC Act, and we will see a slight variation and the expansion of the scope of the offense beyond what obtains in the public sector. Under the Corrupt Practices and Other Related Offences Act, which has been abbreviated as the ICPC Act, sections 8 and 9 of the Act improved on the provisions of sections 98 and 98A of the Criminal Code. In section 8 of the ICPC Act, which is equivalent of section 98 of the code, the words "any person" is used to replace any public official, and the scope of official function was expanded to include matters connected with the affairs of a corporate body or other organization or institution in which the offender is serving as an official. So the redrafting of the provision in section 8 of the ICPC Act ensures that the offense will now cover a situation where the parties to the offense are not public officers. So if the parties to the demanding and the receiving of the bribe are officers of private sector operating entirely in the private sector domain without any public officers being involved. Section 8 will now covers that act. Similarly, Section 9 of the ICPC Act, governing the supply side of bribery, is expanded to cover giving or offering property or benefit of any kind to public officers or any other person. The use of any other person ensures that the provision covers parties who are not public officials. So again, the scope of the offense has been expanded. Now, the mental element of the offense under sections 8 and 9 of the ICPC Act relates to the same element of corruptly under sections 98 and 98A of the Criminal Code. Now, the provision of section 10 of the ICPC Act is like section 98B of the Criminal Code, criminalizing corrupt demand by persons on account of official duties of a public officer. So we can see that, number one, under the ICPC Act, the scope of the offense is expanded beyond public officers to cover non-public officers, both on the demand and the receiving side, the demand and the supply side of bribery. Okay? But the mental element is still the same. The mental element must still be corruptly. The property must have been demanded or received corruptly, meaning bringing in the dictum of Biramian J in Biobaku and the police. Okay? So that is the difference between the provisions of the ICPC Act and the Criminal Code. In one Koala versus Federal Republic of Nigeria, 2018 Law Pavilion Electronic Law Report, the Supreme Court held that the ingredient of the offenses under Section 8 and 17 of the ICPC Act are as follows: that the accused person is a public officer. Number 2, that the accused person receives or obtains any property or benefit of any kind for himself or for any other person, for anything already done or omitted to be done, or for any favor or disfavor already shown to any person by himself in the discharge of his official duties, or in relation to any matter connected with the function, affairs, or business of a government department or corporate body or other organizations or institution in which he is serving as an official, that he has for the benefit in the course of his official duties, that the accused person failed to report the offer of gratification to any officer of the Independent Corrupt Practices Commission. So we can see the ingredient as outlined by the Supreme Court, Nwankwo versus Federal Republic of Nigeria. You can also see the case of Farouk Lawan versus Federal Republic of Nigeria. Now we're going to look at bribery under the Penal Code. Section 115 of the Penal Code criminalizes public officers taking gratification. Let me, adjust my window blind so that we can have more lighting. There is power failure, so you can see that the video is a bit blurry. So just give me a second. Yeah, I guess that's a little bit brighter. Okay, so we can manage it like that. So we're looking at bribery under the Penal Code. Section 115 of the Penal Code criminalizes public officers taking gratification in respect of official acts. That is the demand side. In Federal Republic of Nigeria versus Ademola, 2021 Law Pavilion Electronic Law Report, the court held that the ingredients of the offense under Section 115B of the Penal Code are as follows: that the accused was a public servant, that he accepts or obtains or agrees to accept or attempt to obtain gratification from any person for himself or for any other person, that the gratification was not legal remuneration. Oh, sorry, there's a typo there. that the gratification was not legal remuneration, that he accepted the gratification as a motive or reward for showing or forbearing to show in the exercise of his official functions favor or disfavor to a person. The physical element of the offense is accepting, obtaining, or agreeing to accept or attempting to obtain from any person for himself or for any other person any gratification, whether pecuniary or otherwise, other than lawful remuneration. In Queen versus Bocos, the court held that the gist of the offense is a public servant taking gratification other than legal remuneration in respect of an official act. The court added that it is not material to inquire what effect, if any, the bribe had on the mind of the receiver. Any payment for doing any official act under Section 115A qualifies as bribery. So once you can prove that a public officer, has taken gratification, which is not his legal remuneration in respect of an official act, then that is sufficient for the offense. Now, the mental element of the offense is that the gratification is the motive or reward. Now, talking about the mental element of the offense is that the gratification is a motive or reward for a doing or forbearing to do any official act. Just give me a second. I need to close my door. The mental element of the offense is that the gratification is a motive or reward for doing or forbearing to do any official act. So if it can be proven that the public officer has taken gratification as a motive or reward for performing his function, the offense is complete, because a public officer is not expected to take any gratification other than legal remuneration, other than his salary, for performing an official act. So once he takes gratification for performing an official function, then the offense is committed. The gratification so like I said, the mental element of the offense is that the gratification is a motive or reward for A, doing or forbearing to do any official act, or B, showing or forbearing to show in the exercise of his official functions favor or disfavor to any person, or rendering or attempting to render any service or disservice to any person with any department of the public service or with any public servant. So once a public officer receives gratification as a motive or reward, so in other words, he's performing his official function motivated by the gratification. He's supposed to perform his official function without any motivation based on gratification, or receiving any reward based on gratification. All he's required to do is just to perform his official duties. So once he receives a gratification as a motive or reward for doing or forbearing to do his official functions, the offense is committed. For showing or forbearing to show in the exercise of his official functions favor or disfavor, the offense is committed. For rendering or attempting to any rendered service or disservice to any person with any department of the public service or with any public servant, the offense is committed. In State versus Aoyang, the court adopted the following meaning of motive and reward. Thus, motive implies that the gratification is given in anticipation of favor to be shown subsequently. Gratification is given in anticipation of favor to be shown subsequently. Reward, that it is given in consideration of a favor already bestowed, but the bribe must be given in consideration of some official act. So when it takes the gratification, when the gratification is an anticipation of favor to be shown, it takes the gratification intending to show favor subsequently. With respect to official action, the offense is constituted. Or after having performed the official action, he now takes a gratification as a reward. He's also not supposed to be rewarded for his official action. His reward is his lawful remuneration. So there's nothing like, what people say, after a public officer has rendered a service to you, you say, this is just to appreciate you. No. That appreciation is a reward for the official function. So you're not supposed to take any reward for your official action. Your reward is supposed to be your legal remuneration. So anything you take as a public officer beyond your legal remuneration, either as a motive for performing the official function or as a reward after the official function has been performed, constitute the offense of receiving gratification under the provisions of the penal code. The first mental element for the offense is that the gratification is a motive or reward for doing or forbearing to do any official act. So if the gratification is the motive or reward for doing or forbearing to do any official act, for doing or forbearing to do any official act, then the offense is constituted. In Queen and Bocos, a police officer who received money from a suspect and refrained from arresting and prosecuting a confessed thief was convicted. His duty was to arrest and prosecute the thief. But he received money from him, and he did not arrest him, he did not prosecute him. So that constitutes the offense there. The second element, mental element, is that the gratification is the motive or reward for showing or forbearing to show in the exercise of his official functions favor or disfavor to any person. Under the first part of the above provision, if the public official received gratification as a motive or reward for showing favor in the exercise of official function, an offense is committed. So, because a public officer is not supposed to show favor, you are supposed to perform your official functions honestly and impartially. But if you now receive gratification as a motive or reward and you now show favor in the exercise of your official function, that is an offense. Now, under the second part of the above provision, if the public official received gratification as a motive or reward for forbearing means choosing not to do. So if you receive gratification for not performing your official functions, then that should be an offense. For choosing not to do, to show favor or disfavor in the exercise of official function, an offense is committed. Now, this provision appears to be a bit clumsy. What the provision is targeting is receiving gratification and then as a motive or reward for refusing to do your official duty. That is an offense. You receive gratification as a motive or reward for refusing to do your official duty. That is an offense. But the way it is crafted, it says, forbearing to show favor or disfavor in the exercise of official function. The provision is a bit clumsy because it is suggested that the public officer received gratification as a motive or reward for choosing not to show favor or disfavor in the course of official duty. A public officer is not employed to show favor or disfavor. Okay? A public officer is not employed to show favor or disfavor. So the provision is a bit clumsy. It is not therefore surprising that it was held in the case of State and Ayonga that on the facts of the case, forbearing to show favor, that is choosing to show favor, is illogical. They accused a public servant was charged with accepting gratification as a reward for forbearing to show in the exercise of his official function favor, contrary to section 115 of the Penal Code, in respect of 10 naira alleged to have been handed to him in anticipation of a favor. It's a bit, the provision is a bit clumsy. Now, the third alternate leg of the mental element of the offense under section 115C is that the public officer must have received gratification as a motive or reward for rendering or attempting to render any service or disservice to any person with any department of the public service or with any public servant. This provision will cover a situation where a public servant obtains gratification to assist another person to process a claim or application for approval pending before a government department other than the department where the public officer is ordinarily employed. For instance, I am employed in the Faculty of Law. If I receive gratification from a student who is in a Department of Chemistry, to assist him to gain favor with respect to an exam that he wrote and he performed badly, to induce the lecturer to give him an A grade. So what I have done is to receive gratification as a motive or reward for rendering or attempting to render any service or disservice to any person with any department of the public service or with any public servant. I am not employed in the chemistry department, but what I'm doing is to, assist somebody to corrupt public service in the chemistry department. It will also cover a public servant who accepts gratification to induce another public servant to take an action detrimental to the interest of any person who has an official matter pending before any department of the public service or with any public servant. So if the gratification is to induce another public servant to take a detrimental action to the interest of any person who has an official matter pending before any department of public service, then that will also be the offense. For instance, I've obtained, somebody has given me gratification to induce a lecturer in chemistry department to fail a student, an otherwise A student, excellent student, who ordinarily would have scored an A in an exam, to induce the lecturer in chemistry department to return a failed grade for that student. That will constitute an offense under this provision. Section 118 of the Penal Code is the equivalent of Section 98A of the Criminal Code, criminalizing the supply side of bribery. Section 118 provides that whoever offers or gives or agrees to give any gratification, whatever, whether pecuniary or otherwise, in the circumstances and for any of the purposes mentioned in Section 115 and 116 of this Penal Code, shall be punished with imprisonment which may extend to 3 years, or with fine, or with both. Section 116 of the Penal Code is equivalent of Section 98B. It criminalizes taking of gratification in order to influence public servant. Note, however, that the Penal Code imposed a penalty of 3 years imprisonment for offenses under Section 116 and 118. Section 119 covers public servants obtaining valuable things without consideration from persons concerned in proceedings or business transacted by such public servant. On the distinction between the scope of Section 119 and 115, see the case of Okuwa versus the State, 1964 Law Pavilion Electronic Law Report. Now the question is there any justification for different punishment for 7 years under Section 115? Note that under the Criminal Code, bribery offenses under Section 98, 98A and 98B all attract punishment of 7 years imprisonment. So the question then is, why should a similar provision under the penal code attract a different punishment? Note that the penal code, like the criminal code, maintain the focus of bribery offenses on public officers. Just like under the criminal code, the offenses of bribery under the penal code are also focused on bribery involving public officers, and we have said that there's no reason for that. Now, note that the Criminal Law of Lagos in Section 83 creates a new offense of bribery involving persons who are not public officers. Note also that the punishment for the offense under Section 83 is also 7 years imprisonment, underscoring the fact that bribery involving non-public officials is as serious as bribery involving public officers. So, Section 83 of the Criminal Law of Lagos has created a new offense of bribery involving persons who are not public officers, and it attracts the same punishment of 7 years. This is also the provision. This is also the position under Section 88 of the Criminal Code of Edo State, creating the offense of bribery, the offense of private officials demanding bribe. Note that the United Kingdom has repealed the Prevention of Corruption Acts 1989 to 1916 and enacted the Bribery Act 2010, abolishing the public-private dichotomy in bribery offenses. So in the UK now, the focus of the offense of bribery also covered both public and private sector participants. There's no longer any public-private dichotomy in bribery offenses. The Prevention of Corruption Acts of 1889 to 1916 has provisions which are substantially similar with sections 98 and 98A of the Criminal Code. But under the Bribery Act of 2010, this dichotomy between public and private bribery offenses has also been abolished in England, so that the offense under the Bribery Act now covers both public and private sector participants. There is also the offense of extortion by public officers. Now, this offense is created under Section 99 of the Criminal Code. Section 99 of the Criminal Code creates the offense of extortion by public officers. The provision prohibits public officers from taking or accepting from any person for the performance of his duty as such officer any reward beyond his proper pay and emolument. The penalty is 3 years imprisonment, suggesting that the offense is not as serious as bribery under Section 98. Now, what Section 99 is trying to say is that if a public officer, after he has performed his official function, is conferred with a property or benefit, that constitutes the offense of extortion. And that, according to Section 99, is a lesser offense than the offense of bribery under Section 98 and 98A, because here the focus of the public officer receiving the benefit or the gift is not to sway or deflect him in the performance of his official duties, but it's only a reward after he has performed the official duty. In the case of R and Idioma, the receipt of money by a police officer to release a police extract report of an incident violated the provisions of the section 99, because the money was received to carry out his duty and not for any corrupt or improper act in the discharge of the duty. Now, the distinction between Section 99, 98, and 98A is that in Section 99, the provision covers where a public officer is rewarded for the performance of his duty, whereas The objective of sections 98 and 98A is to prevent a public officer from being influenced in the discharge of his duty. It also follows that there is no intent on the part of the giver to improperly influence the public officer to perform his duties, otherwise the giver will also have been liable under section 98A. The provision of section 99 establishes an offense like illegal gratuity under U.S. federal law. Now, under the U.S. Federal Anti-Bribery Act, there is also the offense of illegal gratuity, which is different from bribery. The legal gratuity targets where the public officer is given a gift or a property or benefit of any kind as a reward for performing his duty. It's not to influence him or to sway him in the honest and impartial performance of his duty. So this was perceived to be a lesser offense. But the big question is whether there is any policy consideration that supports the retention of that distinction. Unlike the position in the US, there is no distinction under the UK Bribery Act 2010 between bribery and illegal gratuity. So under the UK Bribery Act, there's no distinction. Whether you receive the thing for the purpose of being influenced in the performance of your duty or as a reward after your duty has been performed, the offense is offense of bribery. Now, we should note also that there's no replica of section 99 of the Criminal Code in the ICPC Act. It is also important to note that section 115 of the Penal Code does not distinguish between bribery and illegal gratuity. In fact, under the Penal Code, once you receive any gratification, either as a reward, either as a motive or reward for the discharge of your official duty, the mere receipt alone constitutes the offense. There is no question of whether you receive it for the purpose of being swayed in the performance of your duty or to influence the officer in the performance of his duty. No. Any gratification, otherwise than lawful remuneration, received as a motive or a reward for the performance of official duties under the Penal Code constitute the offense of bribery. So in other words, what will have constituted an offense under section 99 of the Criminal Code will constitute an offense of bribery under the Penal Code. So the question then is there really any policy justification for retaining the provisions of section 99 of the Criminal Code? We can see that under the ICPC Act, it is not retained. And then the more problematic question is, if we should ask, in the scenario I gave earlier, a student approached me and gave me a golden Rolex wristwatch. Soon, with criminal law exams approaching, and I take it, and the student, or let's even say, this after the exams, the student had an A in the exam, and the student approached me and said, excuse me, thank you very much, I really enjoyed the criminal law and I had an A, and he gives me a golden Rolex watch. Now, there's no way we can say that that gift was given to me corruptly to influence me in the performance of the student in the criminal law exam, because the exam had already been taken. Okay? But then, if that information becomes available in the public domain, the impression that other students will have is, okay, no wonder, it does not matter, he gave him the thing after the exam. Maybe there was an arrangement between them before the exam that he was going to favor him, so he now brought it after the exam. You know, the impression it will still live in the minds of ordinary members of the society is that the student is likely to have corruptly induced me, even though it was given after the act. Because people will say, who knows whether there was an unwritten discussion, an unwritten agreement between them that after the exam, if the student had an A, then he will give the lecturer and the lecturer will receive it. So sometimes it is very difficult to be able to determine whether something is given as a reward for performance of official duty or as an inducement. And that may justify the approach taken under English law, not to create any distinction between bribery and what they call illegal gratuity under US federal anti-bribery law, or what is called the offense of extortion under section 99 of the criminal code, which equivalence does not exist under the ICPC Act or under the provisions of the penal code. So we're going to stop here for this presentation. So I expect that you should take time to listen to this lecture over and over, and then so that you can come to class prepared with your questions, and I'll be able to take you through. Thank you for listening. God bless.